Greetings to all, you have arrived at Reporting from USA. The continuing legal drama involving Michael Cohen, the former lawyer for Donald Trump, is going to be covered in depth today. The attorney representing Cohen recently testified in favor of continuing the case, arguing against former Trump administration Attorney General Bill Barr. Now we can dissect the main ideas. Cohen claims that the Bureau of Prisons unduly limited his freedom while he was housed in a correctional facility, and this is the central argument in his case. Cohen allegedly received a message from the Bureau of Prisons stating that his release from home confinement was contingent upon his agreement not to discuss Trump or speak to the press. After Cohen turned down these terms, he was returned to prison and put in solitary. A judge ultimately decided that Cohen's First Amendment rights had been infringed, allowing for his release during the height of the pandemic. The significance of restoring the right of every American to speak openly about their government without fear of incarceration was stressed by John Michael Doherty, Cohen's lawyer. The argument goes on to say that Trump tried to have Cohen silenced by using the prison system, with help from his attorney general and officials of the Bureau of Prisons. Doherty claims that the court stepped in to stop the abuse. As Trump campaigns for re-election in 2024, promising vengeance and saying he wants to use the federal government against his opponents, the case brings up questions about possible misuses of power. Cohen argues in court that the power to use the Department of Justice and the prison system as weapons against an enemy should not rest with any president. The president reportedly wanted his former associates and officials who were critical of his administration investigated by the Justice Department. Such targeting of enemies, according to Cohen, is both unlawful and contrary to democratic ideals in the United States. If he is successful, Cohen's case could prevent the executive branch from doing anything that violates people's basic rights. Michael Cohen's attorney recently issued a statement praising his client's major triumph in the Southern District of New York as District Court. In its ruling, the court recognized the Trump administration's actions as retaliation for Cohen's rights violations. In arguing that the court's reluctant dismissal of Cohen's suit constituted a serious violation of his rights, Doherty, Cohen's attorney, cited a different judge from the same court, substantiating the necessity for a remedy against an errant president and his associates. The statement conveyed gratitude to the Second Circuit Court of Appeals for taking into consideration the district court's requests to address the matter. During the court proceedings, the Justice Department, Cohen's attorneys, and Alina Habba, Trump's lawyer, all made arguments in an effort to censor critics. Less than 30 minutes passed throughout the entire session, with 10 minutes allotted to each side. Reports indicated that Habba's presentation was noticeably condensed. Although Trump's attorney, Habba, was the center of attention, the appeals panel asked challenging questions of the Justice Department prosecutors. Habba referenced the case Nixon v. Fitzgerald, in which a civilian analyst was fired for testifying about inefficiencies and cost overruns in answer to a judge's inquiry regarding deterrence. She was speaking about deterrence when the judge cut her off to inquire whether she was admitting that no deterrent was available. Despite Trump's actions, Habba argued that Cohen's release acted as a deterrent. The deterrence of such behavior by a president and the continuing legal battles surrounding Cohen's case were illuminated by the exchange in court. Habba, Trump's attorney, made the case during the hearing that the judge's decision in Cohen's case would discourage similar behavior in the future. She pointed out that one important safeguard is the division of powers. Nevertheless, the judge interjected to inquire as to how the president's official capacity is not implicated in the claimed vengeance arising from a personal grudge. In order to emphasize the importance of addressing the particular accusation, the judge sought explanation on this matter. Habba retorted by saying that there wasn't enough evidence in the complaint to prove that Trump had any hand in planning the reprisal. She reiterated that the accusation was based on Cohen's interpretation and assumption. Cohen and his investigators collaborated with lawmakers to unearth more than 450,000 documents pertaining to his case and the reprisal, in contrast to the Nixon case that had actual recordings. Habba corroborated the judge's assessment that the complaint lacked substantial evidence and was thus too conclusory to be considered. As further evidence that Trump does not enjoy absolute immunity in civil proceedings, the judge cited the recent decision of Blasting Game v. Trump. The judge explained the case's relevance to presidential immunity after Haber said he didn't know much about it. Bivens, a case involving official acts, takes precedence over Haber until the Supreme Court rules on the matter. By highlighting that the matter at hand concerned presidential immunity, the judge made the difference clear. As part of his lawsuit, Cohen claims that Trump used his executive authority to stifle dissent by targeting individuals who were acting in their official capacities. According to Haber, Trump was acting within the scope of his presidency, and Cohen's claim fails due to absolute immunity. The judge thanked Haber for her time and eventually ended the proceedings as the hearing progressed. The difficulties faced by Trump's legal team in defending against allegations of retaliation were highlighted by the tough questioning. There has been an investigation by Letitia James into Trump, the Trump Organization, and his 3 adult children. In September 2022, she took legal action by suing them, claiming that they had inflated property values and falsified financial documents. They allegedly overstated the value of their properties to get better deals from insurance companies and lenders. The trial is still continuing, even though the defendants have consistently denied anything. In the Big Apple, the Trump legal team recently lost an appeal to overturn a trial-related gag order. Trump cannot use his public platform to criticize court staff, which is why the gag order was imposed. According to Trump's most recent tirade on Truth Social, he maintained that his assets were being undervalued, not exaggerated. Letitia James claims that he exaggerates his wealth by billions of dollars compared to his conservative financial records. In his financial documents, Trump highlighted the disclaimer and non-reliance clause, stating that users are responsible for conducting their own analysis and due diligence. He said the judge, Arthur Engoron, should have tossed the case outright instead of trying it. Trump has previously voiced his desire for a favorable outcome and the respect of the New York State court system. Drama has been abundant during the trial, with Trump exploding in court and the court issuing numerous gag orders in response to threats. Regardless of the obstacles, Judge ENGORON has expressed his intention to miss the case once it is over. It's worth noting that Trump has been quite outspoken in his criticism of the people looking into him, especially Letitia James, whom he has accused of political bias and has referred to as leading a witch hunt. In a recent unanimous decision, an appeals court in Michigan upheld Trump's eligibility to run for president in the Republican primary in the state. His activities in relation to the events that transpired at the US Capitol on January 6, 2021, formed the basis of the challenge leveled against him. A 3-judge panel rejected his attempt to disqualify him under the 14th Amendment's post-Civil War clause, citing the impending presidential primary election as the sole relevant event. The court ruled that Trump's ineligibility to run for office due to the 14th Amendment's specified clause had no bearing on his primary ballot position. Consequently, they came to the conclusion that, at least for the moment, there was no genuine controversy. It must be emphasized that the court refrained from explicitly ruling on the question of Trump's disqualification under the 14th Amendment. The primary election and its procedures were the primary foci of the decision. The challenge was deemed frivolous by Trump campaign spokesperson Stephen Chung, who emphasized the campaign's successes in lower courts and dismissed the case as such. Some parties are trying too hard, he said, to cast doubt on Trump's eligibility. Notably, comparable challenges in other states, like Minnesota and Colorado, have also failed to prevent Trump from being included in the ballot by arguing against his eligibility under the 14th Amendment. How do you feel about a Michigan court's ruling as this legal drama continues? Leave a comment with your thoughts and feelings. This quick response, which happens within a day, is a change from the usual lengthy legal processes that can take years to reach a conclusion. The court has not yet determined whether Trump's appeal regarding the January 6th case is meritorious, but this early action does show that they will not let Trump's attempt to delay the proceeding succeed. The expedited decision by the Supreme Court, according to a former federal prosecutor named Gene Rossi, portends ill times for Trump. According to Rossi, the court members are essentially skipping a lower court to send a message that the legal proceedings must proceed quickly because they cannot afford to wait. The president's special counsel, Jack Smith, asked the Supreme Court on Monday to expedite the decision on an appeal Trump had filed. In the DC criminal case involving Trump's purported efforts to sabotage the 2020 election, the subject is his quest for immunity. While the appeals court deliberates, all deadlines related to Trump's case have been put on hold. Smith acknowledged the request's peculiarity and emphasized that this was an exceptional case. The urgency with which the Supreme Court has taken up the case shows how serious it is. The practicality of Trump's attempts to delay the proceedings through the use of legal tactics is now called into question by this new information. Who knows what the Supreme Court will do next, but their signal suggests that Trump might not gain anything from delays. Trump recently petitioned the appellate court to dismiss his case and speed up its review. His legal team even went so far as to compare the special counsel's behavior to the Grinch, trying to rob the legal team and support staff of Christmas. On March 4th, the trial of Donald Trump is set to commence in the nation's capital, presided over by Judge Tanya Chutkan. Despite repeated attempts by Trump's legal team to delay the trial, Judge Chutkan has steadfastly refused to do so and has even threatened to do so in the event that Trump violates his gag order and assaults witnesses. Regarding Trump's continuing legal challenges, what is your opinion? Leave a comment with your thoughts and feelings. As he gears up for a potential run in 2024 election against President Joe Biden, he faces 4 criminal cases, maintaining a plea of not guilty in all of them. Despite these legal challenges, a Reuters Ipsos poll indicates that Trump continues to command a significant lead among Republicans, with 61 expressing their support for him in state-by-state nominating contests. The outcome of these legal battles could shape Trump's political future and impact his standing in the 2024 election. As always, we'll be keeping a close eye on developments, so stay tuned for more updates. In spite of his appointment of 3 conservative majority justices to the Supreme Court, Donald Trump has been unsuccessful so far in his attempts to push 4 imminent criminal trials beyond the next election. The Supreme Court's prompt response to special counsel Jack Smith's pressing request demonstrated its disinclination to cooperate with Trump's legal maneuver. Surprisingly, the Supreme Court showed an extraordinary feeling of urgency by agreeing to expedite Smith's request. Much obliged for your time. Give the video a thumbs up and subscribe to the channel if you enjoyed it. We have other videos that you might enjoy. Until the next video, take care.